I will remind all present that mobile phones must be switched off before the meeting and that the meeting is being recorded and live streamed. Please be aware we have a 5-minute time limit on speeches in the chamber. You will hear a bell ring at 4 minutes and then another at 5 minutes. If you could please wrap up your speech in that last minute, that would be great. I'll also remind speakers that councillors may ask you a question, however, you are under no obligation to answer, and speakers are not to ask any questions of councillors. I'll also remind speakers that they have 1 minute time limit in reply to questions from councillors if any are asked. And lastly, please stick to the topic of your item in the agenda so that I don't have to bump you back on course. First up, I should say we're missing Councillor Duffy. She's heavily pregnant, but will be attempting to attend the 5:30 meeting, and Councillor Kent does have a conflict, so that's why he's not in the room. With that, Mr Barry Anstey is speaking for the recommendation in item 6.1.
Mr Mayor, I'd like to make a procedural motion, please.
We're not in a meeting, sorry, Councillor.
Regarding the Code of Meeting Practice.
So, Councillor, we're not in a meeting. We're in a public forum. So there's no code of
then I
meeting
have a
here.
question. As per 4.9, the Mayor and GM are able to exercise discretion and increase the number of public speakers in this public forum. Have you exercised
Yeah, we've
this
considered that.
discretion?
We've always stuck to 2 speakers for, 2 speakers against, so we've discussed that and we're going to stay as is. Thank you.
Okay, so, sorry, has the discretion been exercised to
Correct.
increase the number
No,
of
we've
speakers?
chosen to rein at 2 speakers for, 2 against. Thank you, Councillor. Mr Barry Anstey.
Thank you, Mr Mayor, and thank you for allowing me to speak today. I point out that I'm speaking for myself personally. I'm not influenced or representing any party, as much as people have tried to. What I say today is not legal advice. It's my own opinions of the position of where we are. I would point out that I have a degree in architecture, and I have, over the period of the last 50 years, been heavily involved in instructing solicitors and briefing senior counsel and counsel in relation to land and environment court matters. So therefore I know a fair bit about the process of where we are. I lodged a submission to the IPC when we were invited to, and I spoke at the panel meeting that. A copy of that submission I gave to Susan Stannard and a copy to Michael McCabe back in December of this year. Principally, that submission focuses on the fact that this development is prohibited now on the site. Where it is prohibited, it's not been assessed in those respects by the IPC or the Department of Planning. So in that respect, it's fallen through the cracks. Therefore, in where we are, I attended a public meeting on last Tuesday, and at that meeting I stood up, and there was a number of councillors there where I said that I intended to intervene. I have since taken the steps of corresponding with the IPC solicitors, and corresponded with them and had discussions with them. I've also spoken with the Land and Environment Court and had discussions with them. My intention is, depending on what happens today, because since I made that statement, the council has had this extraordinary meeting, my intention is to file a proceeding or intervene on the basis that under 8.15, which Mr McCabe refers to in his thing, to ask that the court hear the matter of a special question in relation to permissibility, and that the contradictor to that be the council. And the court has the power to adjoin the council to do that. My suggestion is that the council should resolve to have a special question, put to a special question themselves, and seek what's called a double bay marina order where you limit costs to just what you ask to seek. Because if you allow the court to adjoin you, then you might get joined to the whole proceedings and the whole cost that you're concerned about. Because that's the concern in what I read the report. The concern of Mr McCabe is $500,000. I think he's underestimated by an enormous amount. But I think we can get rid of this thing in a very short period of time on a special question of permissibility. Now, you need to seek advice that there's an arguable case on permissibility. Mr McCabe, I think, is already across the issue, speaking to him a couple of times in the last couple of weeks. If it's arguable, then run it and let's get rid of it. That's basically all I have to say.
Thank you, Barry. Any questions? Thank you very much. Next, we have Dr. Raymond Curry. He is speaking against recommendation item 6.1.
My name is Raymond Curry and I'm speaking on agenda item 6.1. Mayor, councillors, General Manager and directors. The community, which includes council employees, is crying out for leadership from councillors. Section 5 of the 2035 Community Strategic Plan requires council to, quote, advocate for the things that matter to the community, unquote. This is a critical issue that means so much to the community. The notion that legal cost must come from road maintenance has infuriated community leaders because we know that 44% of the community rank road maintenance as its #1 concern. Recently, our mayor was in Macquarie Street seeking road funding because, simply put, we do not have enough funds for roads. So, this begs the question, how can we reallocate funds from the roads budget when there are no surplus funds to reallocate? So, where will legal costs come from? The current plan to upgrade lights at sports fields will cost us between $2 and $6.5 million. Mayor and councillors, the sports fields already have lights. What if $500,000 was reallocated from upgrading the lights to cover legal costs so we can confront this important community issue? The Open Space and Play Strategy 2025-2030 is allocating $0.93 million to renew skate parks, not build them, renew them. The reallocation of half this budget would cover legal costs. The damage to the community far outweigh litigation. For example, in Council's submission to the IPC last year, 2 of the 6 main concerns were about the innovation park being threatened if the plastics facility was to go ahead. The mayoral minute of 19th March stated that the innovation park will create, quote, 10,000 to 15,000 jobs, unquote. Within this context, 500,000 is a minuscule amount compared to the enormous revenue generated from the jobs. In the financial years 2021 to 2024, Council was involved in 46 Class 1 appeals. Given this vast experience, why is there resistance to take on one more case? The IPC report informs us that there will be 100 heavy truck vehicle and 280 light vehicle movements every week. A reasonable person may well conclude that the costs in constant road repairs will far exceed $500,000. Miss Samantha Wood deserves praise for her exemplary courage, integrity and commitment to the community. Mayor and councillors, the community is crying out for your leadership.
Thank you, Ray. Has anyone got any questions? Councillor Champion.
Microphone. Thank you, Mr. Curry. Just wanted to clarify, you mentioned 46 Class 1 appeals. Over what period of time was that?
Financial years 2021 to 2024.
And I had a question, and you're referring to items that we were the consent authority, correct?
I'm sorry, but I can't hear you.
Those ones you've identified were ones where we were the consent authority, correct?
Correct.
Thank you. Thank you.
Sorry.
Councillor Russell.
Thank you, Raymond, for your in-depth research. With the cases, did you have a look at what type of cases, what sort of things council was going to the court on in those instances?
I didn't have the details. They're all listed in the annual report. They're all land and environment cases. The 46 are Class 1s. There are Class 4s, which I didn't include in the list. The actual matter, I can't tell you.
Councillor Smith.
And just further to that and adding to the Mayor's question, so I take it if we weren't the consent authority, they weren't state significant developments. Do you have an understanding of that, Ray?
The council was the party.
It's my understanding, and I'll ask if that's your understanding, that we're compelled to join as a party if we are the consent authority. Is that your understanding of it? It's not a choice in that circumstance. We're compelled to join. Is that your understanding of it?
I'm sorry, what are you referring to?
That's okay. That's all good. I'll retract my question. Thank you. Next we have
Mr Mayor, I've got a
Councillor
question.
Moylan.
Thank you.
Go ahead.
Thank you, Mr Curry, for your extensive analysis. As you say, it is very important to the community. I like the way you're comparing the macroeconomics to a line item in a budget. Would you agree with the proposition that we're taking a very narrow view if we're just looking at that budget cut table in the paper?
Yes, definitely. When we assess the whole situation of 500,000, look, it could be more. I acknowledge that. Compared to what the Innovation Park can give us and the threat to the Innovation Park, I think that there's just no comparison whatsoever between our legal costs and even double it compared to the enormous benefit to the Highlands of 10,000 to 15,000 jobs. There is just no comparison whatsoever.
And Mr Curry, on your point about the 46 Class 1 appeals that we've had experience in, is your point that one more Class 1 appeal is a drop in the ocean, as is the 500,000?
Thank you, Councillor. Yes, I mean, after 46 cases, surely, you know, it is obvious that there is a vast amount of knowledge there. So why not use this knowledge and just take on one more case?
Thank you. Next we have Miss Jessica Ryle on Architecture Republic is speaking for the recommendation in item 6.1.
Hi. I think staff might have gotten a bit mixed up with me, so allow me to introduce myself properly. My name is Jess Ryle. I'm the Creative Director at Architecture Republic, a Moss Vale local and a mum to 2 children. And yes, I think that staff's recommendations make sense and I can see the logic. But before I get to why, I want to spend some time outlining how this proposal, Plasrifying, got so far. It's going to be dry, but bear with me. It actually will help you be reassured for your vote today. Right, so how did we get here? In front of you, you can see a zoning map of the proposed factory site. The patchwork mess to the east of the site is not normal. I don't know who drew this. It is old and therefore not anyone's fault, but it is actually nuts. The block itself is split into 2 contradictory zones. Factory land right next to environmentally sensitive land below. Both halves are 1 block though. The gap between is meant for an access road, but this is all 1 parcel of land and that is critical to understanding how this Plasrifying got so far. The houses along Beaconsfield Street are suburban Moss Vale, but this zoning here, with all that beige, makes it look like this is all rural residential and the town ends much further south where that R2 pink zone is. This is not your doing, but it's going to come up in the court case without your involvement anyway. So, that zoning was a foundational argument from the proponent at the IPC. They were able to claim that their factory was not fronting residential land and on the ground, as we know it obviously is. Now, the bushfire mapping, you can see it there. The rules are simple. If any part of a block is mapped as bushfire prone, the entire block needs to be bushfire assessed. A bushfire assessment must be done. Even with this old, now suspended, good job, mapping, there is bushfire prone land here. There always has been. But you can see how someone from RFS looking at this northern part of the site, up there, the E4 section, might get confused and think it's in the clear, which is exactly what happened again in 2023 before any of you were elected, not your fault. So let's pull up the timeline. So council updated its bushfire mapping last month, thank goodness, and provided that the IPC know that that change has been made, that makes a massive difference to the entire LEC case. The old mapping, which we just saw, was from 2011. Everything Plasrifying related has happened in between that 2011 and the 2025 timeframe. In 2015, the RFS Bushfire Prone Land Mapping Guide required grasslands to be mapped as bushfire prone, and any bushfire assessment from that date onwards would identify the entire Plasrifying site as bushfire prone because it's grassland. The EPNA Act says that council must revise their hazard mapping every 5 years. That did not happen here. 5 years after 2011 would be 2016. The new maps should have been published at that date, showing that the Plasrifying block, which is all grassland, is all bushfire prone. No, I'm no lawyer, but I think that this was probably a breach of the statutory duty by that era's council. Again, not you guys, and thank you so much for fixing it. And I would say that this will come up in court without your involvement, fingers crossed. By 2023, that map was 7 years overdue for an update, and the RFS misunderstood the boundaries and missed the bushfire trigger. The site was deemed not bushfire prone with no bushfire assessment required. Plasrifying's team used that RFS letter throughout their DA and IPC process. With no bushfire risk, they can build to the boundaries. With no asset protection zone, they can plant trees and claim that the screening will mitigate neighbour impacts. The dodgy mapping makes their business case look viable, even when it's not. They likely would not have gone this far otherwise. So then it's 2023 and 2024, the administrator doesn't correct the RFS's mistake, the Department of Planning doesn't do it either. Only when the community raises hell with council's help and support at the IPC meetings did the RFS backtrack. And that was literally days before the IPC refusal was published. Wingecarribee is one of maybe 3 councils that let the hazard maps go this stale for this long, and it's definitely the closest one to Sydney. Here's what GHD said in their applicant meeting with the IPC last year. Hopefully this comes up in the court case. The team originally looked for land for the factory in 2020 in the greater metropolitan Sydney area around Kemps Creek and within the emerging Aerotropolis. No land was available. But what we found was the Moss Vale Enterprise Corridor. The land was cheap. Wingecarribee's unique patchwork zoning and outdated bushfire mapping made it appear developable when it was not. The door was left open and it was only a matter of time before a developer walked through it. And that is how this happened. And this is all legacy mistakes. None of this is your fault. And the biggest issue, the bushfire mapping, has now been completely patched up. So here's why it makes sense to follow staff's recommendation. Yes, while most councils would join an LEC case like this, it is still completely legal not to. You're not doing anything illegal. This situation is all just the result of past errors and not your fault. While many in the community might argue that cleaning up planning legacy messes were a campaign promise of yours, following through is definitely more complicated. I don't think anyone's expecting you to swoop in and fix this with a crack team of barristers. You could help, you've got insight, but you need to make this decision for yourself. This is a bigger issue. Does it matter to you? Or maybe it's best to play it safe and not act. After all, that's what your predecessors would have done. Thanks.
Thank you very much. Are there any questions?
Yes, thank you.
Councillor Russell.
Thank you very much for your pragmatic presentation. This bushfire issue, it's a bit of a smoking gun, wouldn't you think? Do you think that they'd bring that argument to the Land and Environment Court?
Sorry, do you mean the IPC would bring that argument? Oh, sorry. I was just clarifying. Do you think that the IPC would bring the argument or the community rep?
Well, either.
I don't know about the community rep, but I would say that the IPC would not. Like I said, the RFS backtracked and changed their mind about the bushfire stuff literally days before the refusal was published. So it is a smoking gun, I agree, but it wasn't in their reasons for refusal, so I don't think it would come up in court. That's probably something someone else would have to raise.
Councillor Smith.
Thank you, Jessica. You had some specific quotes and obviously a lot of research in there. Will you be providing that to Council, the written parts and the statements from your presentation?
I can email them to you if you want. I can also provide the written submission that I did during the IPC process, which goes into stuff much more detail rather than this quick summary.
Thank you very much. Councillor Russell, have a further question?
Thank you. With your research and your observation of the patterns involved, what message do you think Council's decision, if Council were to choose not to become a party, what message do you think that might send to developers watching closely for an open door?
I'm sure there are other open doors with particularly the zoning and the outdated DCP and LEPs that we're working with. And I'm an architect, I work in this shire, and there are one or two little loopholes that we like to keep close to the chest. I mean, I suppose that if council doesn't participate, it would show that you're more, I don't know, interested in the potholes and the immediate budgetary issues, and that takes a priority instead of big picture stuff and legacy planning issues.
Thank you. I've got another question, and I believe Councillor Moylan has some questions as well. Given that this zoning and mapping issue was unique to Wingecarribee, do you think that the process might have succeeded in another council area?
I think that quote that I dug up, let me just read it back, was pretty telling. The team originally looked for land in 2020 in the greater metropolitan Sydney area around Kemps Creek and within the emerging Aerotropolis, which would have made sense, let's be honest. No land was available, but what we found was the Moss Vale Enterprise corridor. Yeah, I mean, they would have faced updated bushfire mapping and consistent zoning in those other areas, I guess. I think it's the peculiar, combination of the outdated maps and the patchwork zoning that kind of made them turn the eye of Sauron to us in the first place, if you will. So yeah, I'd probably put the blame squarely on the legacy planning issues from the old council, which are yet to be fully cleaned up.
Thank you. Councillor Moylan.
Thank you for your contribution to the community and all of the work you've put behind this today. Do you qualify as a formal objector? Did you put through a written submission in the early stages of the process?
I don't think so. I only found out about it when the IPC process started to get underway. I've lived in the Highlands for 10 years now, but I feel like that initial DA was not very well publicised. And if there were more objectors early on, it would have been better for us now. But yeah, no, I don't think I was.
So you're saying, aren't you, that you feel you were deprived of that opportunity to become a formal objector in this important decision for the community?
I think the majority of the community would feel that way. There's a lot of us that weren't aware of that original DA because we weren't up on Bulwer Road. We were, further south, and there's a whole bunch of new subdivisions happening in the area, and all of those people will be affected. I think the initial notification period was just for Bulwer Road. So yeah, definitely.
Thank you very much. Thank you. We now have Mrs. Louise Keats is speaking against the recommendation in item 6.1. Sorry, just, yep.
One moment. Thanks for the opportunity to speak today. I'd like to begin with a quick refresher, because it appears we all need one, on why opposing this plastics factory with every avenue available should be our first priority. Let's remind ourselves that plastics recycling facilities are well known for their horrific microplastics pollution. We know from the research that many thousands of tonnes of invisible microplastics will wash into our water supplies and enter our breathing air from this behemoth. Of most concern, the research shows that it's the smallest nanoplastics that escape filtration systems, but it's these tiniest particles that are the most dangerous for human health because they so easily enter our organs. The prevailing winds will carry these nanoplastics straight over Burradoo and Bowral, where many of our children are at school, and where they will spend their formative years being poisoned daily while their small developing bodies are at their most vulnerable. These nanoplastics will also blow over our farmlands and our homes, affecting land values, agriculture, and our tourism industry. At first, we'll be oblivious to these invisible toxins, but the effects will show up soon enough in our rising cancer rates and our kids' infertility. These plastics will lodge in every one of our organs, especially our brains, which are most at risk. So we may end up becoming one of Australia's dementia capitals, with links now being found between plastics and neurodegeneration. Then there's the fire risk. The expert report of Dr. David Collins found that there's a 30% risk of the repoly site ending up in flames. 30%. And that didn't even factor in the bushfire-prone land. If and when a fire occurs, it will be akin to a bomb going off. In the case of the Indiana Plastics fire that occurred in a similar-sized facility, ash debris from the fire was found 10 kilometres away and thousands of residents needed to be evacuated. The toxicity of plastic fires should not be understated. In the Indiana fire, there it is, let's all look at it, there was hydrogen cyanide, benzene and carbon monoxide in the ground level smoke. Hydrogen cyanide is fatal, while benzene is known to cause cancers like leukemia, multiple myeloma and non-Hodgkin lymphoma. The World Health Organization has said that there is no safe level of benzene exposure when it comes to cancer risk. Dr. Arthur Frank, an environmental health professor, likened the Indiana fire to the World Trade Center, where cancers are still appearing years later in people who'd been nearby. He noted the same toxins are found in plastic fires. Councillors, this is a fight we just cannot afford to lose. The health of Highlands residents for so many generations to come depends upon it. Even the IPC in its 31 July letter is telling us to wake up. They're saying council should reconsider its decision. It is manifestly inaccurate to suggest that the IPC is the one best place to fight this fight for us. The IPC is required to be a model litigant and potentially reach a very damaging conciliated outcome. However, council is not. Council is the best place to represent the community interest. That's what you're here for. And if it doesn't join these proceedings, you are forcing us to go it alone, which just seems so wrong. Please, can we not engage in a scare campaign suggesting that this battle would somehow involve signing a blank cheque? The excellent lawyers for the community group have indicated a figure of $180,000 to run the appeal. Why is council overinflating the cost of involvement? And why is a small group of local residents able to obtain leading legal representation and carefully budget costs, but our own sitting council with all its expertise cannot. And let's be crystal clear, even if the cost was $500,000, which seems unlikely, this amount will pale in comparison to the depreciation in land values and the increased healthcare costs we face if this project goes ahead. For council to suggest that community needs to forego fixing damaged roads to fund the appeal feels manipulative and divisive. What's more, how much damage will the roads be with 100 additional heavy truck movements on them every day? Mayor, the first time I heard you speak was at that IPC public forum, and I thought, here is a man with a fire in his belly who is going to save us from this nightmare. Where is that conviction now, Mayor? We are in our hour of need. More than ever, we need you and our Deputy Mayor and all of you councillors to demonstrate vision and leadership and fight this fight for us. Didn't we make it clear enough with our enormous public gatherings, our 130 speakers, our 3,000 objections and our 7,500 petition signatures that this matters to us? I have never seen a community more united. Please, I implore all of you, do not let us down.
Thank you. Thank you. Councillor Russell.
Thank you, Louise. I was wondering if you could please inform my colleagues of your professional background.
I am a former lawyer. I worked in the law for a decade and I also work in health now.
Thank you. Councillor Molan.
Thank you, Mrs. Keats, for your emphatic representation of the community today. A couple of questions. With your legal background, do you see, and I hope I'm not putting you on the spot here, but do you see a potential for a litigation risk against council if we should go ahead with not litigating?
Obviously, the first thing council needs to do is get proper legal advice on this and a proper cost estimate. It's just a no-brainer. You owe it to the community to do that instead of manufacturing figures. And then you can make an informed decision as to what's the right thing to do. If you think that the IPC are the best place to run this, you are wrong. The IPC are not locals. The IPC are required to be model litigants. That puts them in a very dangerous situation, and they've tried to point this out to you in their letter to you, that they are legally required potentially to reach a conciliated outcome. You are not. You need to represent our interests. You are our council. Why would we rely on the IPC to represent our interests? I know, I take your point, Mayor, that we are not the consent authority. It's irrelevant. You have a strong voice and you need to exercise it. What you're doing is putting $500,000, and that's a unicorn figure because it's been plucked out of the air, unless you can show the cost estimate you've received from a legal team to that figure. You are putting money before our health, and the risk is considerable. I feel that you must have forgotten the risk to be putting that small figure ahead of our health.
Thank you. I just have a question. I can pull it up, but in correspondence from the first respondent of the community, they said seek a refusal or a approval with concession or conditions. You're stating that we don't have to do that. Would you expect council, as a second respondent, as the community, to take that same position as the community respondent?
My understanding, and again, you ought to seek your own legal advice on this, is that you aren't required to be a model litigant, so you're not required, as the IPC is, when it comes to the conciliation requirements. Whereas the IPC might have to agree to approve, to approve the facility with a whole lot of conditions attached, you can stick to the notion that it's just fundamentally the wrong side, and you don't have to conciliate as they do.
Look, I just could confirm we are getting that legal advice in the meeting.
Excellent.
Coming up, definitely. But yeah, just to reiterate, I mean, I know that's not your role in this, but they have made a public statement that they would concede with conditions. And I guess I'll just ask again that.
You're
that
saying
may
the
be-
IPC have made a public...
No, so the community respondent has said in a statement that they will either seek a refusal.
Sorry,
or
I just don't want to say something if I don't understand the question. Are you talking about Sam Wood and her...
Yeah, so that
Okay.
they have said that they would seek a refusal or a approval with conditions. And my question to you was, would you expect
I
council
don't
to-
think that's correct at all. I don't think that's correct at all. I
Look,
think
I
the
can-
position of the community is we would not seek an approval with conditions. We have absolutely no faith that Repoly and that particular company will stick to those conditions at all. I'm sure they're going to promise the world. I'm sure Plasrefine are going to promise world-leading filtration systems and they're going to replace their filters every month. And are they going to stick to any of that? Of course not.
Thank you. Look, I can provide that after this meeting if anyone wanted to see it. That's just what I've seen, but...
My understanding of the community position is that this just cannot go ahead no matter what the conditions. I mean, of course, if it's going to go ahead, we'd prefer a long list of conditions than a short one. But the fundamental position is that this is not the right site and it shouldn't be there because the conditions can't mitigate the fire risk.
Okay, thank you. Thank you very much.
Yeah.
I appreciate it. Thank you. Next we have Mrs. Kylie.
Just before I go, I applied to speak today after Theo Honestfrau. He applied before me, and he is a very articulate former barrister, and I wonder whether perhaps he's been refused on the basis that he's maybe too good. And I just
Thank
feel
you.
that
Thank you.
perhaps...
Mr. Theo, you can speak at the end. Thank you.
You
Look,
can speak at the end.
we have one more speaker. The councillors will remain in the room if they wish to hear from you. There's no need to jump up in the middle of the public forum. Thank you. Miss Kylie Roberts-Frost will be next, please. Thank you.
Good afternoon, councillors. My name is Kylie and I live in the Highlands. I run a national sustainability program authorising recycling sites across the country and previously managed a facility for ACT No Waste. I'm going to start with the awkward bit. I believe in recycling, including plastics recycling. The way we consume plastics today means that we must deal with them as a waste stream. Until we reduce that consumption as a country, we don't get to choose not to have these facilities. But the location of these sites, the scale and the risk controls are absolutely vital. Many of you have heard my concerns about this site specifically, so I won't restate them here. Today is about process and representation for the Southern Highlands. So this afternoon I am speaking for the motion Councillor Russell has put forward. Clause 1 asks Council to consider external legal advice on Council's role in the Repoly appeal, and that is exactly what's needed because something changed immediately after the last Council meeting. On the 16th of July, Council voted on its current position. On the 17th of July, the IPC issued its notice confirming this is a Class 1 merits appeal, not a judicial review. Now, that matters because it makes something really clear. The negotiation will happen in confidential conciliation between the official parties. If Council is not a party, they can attend a short public session, but they're not in the room when conditions are negotiated. So that new clarity is what shifted my view. I actually thought at first that remaining an objector was probably the better option. But alongside the IPC's formal notice, the letter sent to Council made the limits really clear. The IPC and the court deal with the development application in front of them. They can't represent the ship, rewrite zoning, or define advanced manufacturing. What they can do is either uphold the refusal or consent with conditions that govern day-to-day operations on this site. On that basis, I support getting updated legal advice now. Why does this matter in plain terms? Because Class 1 cases usually start with a sit down to see if a deal can be made. And in practice, about 77% of these appeals resolve in or after that conciliation step. If the court consents, that's when the nuts and bolts get written. From truck routes to emissions limits and who pays when things go wrong. That is everyday life in our community and it's our council's budget. Councils don't join every IPC case, and nor should they, but they do join when local impacts are significant. We've seen it in 3 cases in recent years. Those councils joined to protect their community, manage risks, and ensure conditions reflect local realities. And councillors, that is the decision in front of you now. On the costs, $500,000 is significant, and as residents, we need that honesty. But framing the legal budget by listing community projects that might not proceed risks a false comparison. Defending the IPC refusal isn't discretionary in the way a playground upgrade could be. It's a protective spend to reduce bigger downstream costs, road maintenance, emergency responses, costs that don't show up in this year's line item, but land with council for years to come. You can also keep that legal spend controlled by coordinating with the IPC's lawyers to avoid duplication, and could even set a public cost cap with milestone reporting. That brings me to clause 2 of the motion, conduct any business arising. My request is straightforward. Consider the advice and then act on it. If the advice says seek joinder now, authorise the GM to file immediately so council is at that first conciliation. If the advice says reserve rights but file a full conditions package, authorise that now as well. Either way, you are keeping our community represented where decisions are made. If conciliation goes to consent, bring conditions that protect residents and put the risk on the proponent, from feedstock caps and continuous monitoring to independent audits and automatic stand down on breaches, fire suppression and financial bonds with a sunset clause. Councillors, I do not envy the decision in front of you. You have a lot to consider and not long to do it in. If the court ultimately leans towards consent, being a party means those decisions are made with council and the community you represent in the room. Please choose that path in your meeting this evening. Whether the refusal stands or conditions are imposed, we will know as a community that we did everything we could. Thank you.
Thank you very much. Any questions? Councillor Russell.
Thank you. Is your presentation able to be emailed to councillors?
Yes, I've actually just emailed it through.
Thank you. Councillor Russell.
And I'm really grateful for your weighing up of those risks and costs for us. Would you perceive from your experience that by investing this amount now in in joining as a party, that could actually save us exponential costs in firstly stopping the proposal, but then if it goes through conciliation, ensuring that we've got the right checks and balances in place to make sure that any costs of this potential development are mitigated and controlled?
Yes, that would absolutely be my advice. Just looking at the data, and I went down a Google rabbit hole on the weekend. Sometimes ADHD is a force for good. If we look at the data, 80% of these are dealt with in the conciliation stage. So I think it's vital and could save council a lot if you are in that room and have the ability to enforce conditions.
Thank you. Councillor Russell.
Oh, just let Councillor Smith ask a question first.
Councillor Smith.
Thank you. Are you aware that we will be receiving legal advice after this in our next?
Yes, I am. When the motion was then published, so I did have to tweak the speech to fit.
Thank you.
And one more question. You mentioned that there've been 3 cases in the last few years of councils going to the IPC. Do you have 2 questions? Can you outline, do you know what they are, or can you send them to us? And are we talking 3 out of 5 cases? Are we talking 3 out of hundreds of cases? Do you have, you may not have the answer, but I'm interested.
I do have some of the answer to that. I definitely think it's worth flicking through to your legal team to confirm. The 3 cases I found were directly related IPC appeals, 2 where the councils were supporting the IPC's position and 1 where they were actually in difference to the IPC position. So those were the 3 main ones, and I found 19 in total IPC cases. So I've flicked them through to all the councillors now.
Thank you. Councillor Russell.
In your experience with recycling and the whole waste business, have you found that the EPA is effective in managing conditions post-consent?
That is a very loaded question. I think that EPA has the tools and levers to do that. I think that it is very challenging in we see this broadly, right? Veolia and Suez and some of our waste contractors are losing a truck a week in New South Wales to lithium battery fires. Now, that's not because they're bad operators. It's not because the EPA is doing a bad job. It's because the framework and the construct that they're working in makes it really challenging to do that. So what I would say is, even if this proposal goes through the IPC, it still has to be approved by the EPA. I know that there has been, we can't discuss the proponent and their fitness to operate the site in this context or in the IPC or any previous stage. The time for those conversations around the proponent's fitness to operate will go to the EPA. So that will be the time to have those conversations. And there is a very, there are hugely talented, focused people working in that department, but they obviously operate under the same constraints all the rest of us are.
Thank you. Councillor Russell.
Yeah, sorry, to be clear, it's more just my understanding of the resourcing that the EPA has to enable those relevant levers, which I've been informed they're a bit stretched with resources.
Yeah, look, there's always a difference between having the lever and then having the ability to enforce it. Yes, that would be my answer to that.
Thank you. Councillor Champion.
Ms Roberts-Frost, thank you for doing all the research that you've clearly done. The Google rabbit hole is appreciated. I just wanted to ask, given that you have a lot of highly relevant expertise and no doubt networks in the sector in waste, should council be in need of it, are you aware of or are you able to assist with us accessing experienced consultants and expert witnesses in this case?
Yes, absolutely. I think it's wonderful that we now have the most engaged community around waste and resource recovery, probably in the whole of Australia now. But yes, there is hundreds of really, really talented people working in this space, and I would be happy to connect council with them.
Thank you very much. Councillor Molam.
Thank you for coming along today and contributing to the debate. I like your use of the term protective spend. Would you say that, would you agree that the role as formal objector is a weaker role, given, to your point, we won't have visibility on the conciliation conference and indeed any of the conditions? Could you reiterate that point for us?
Yeah, absolutely. So obviously I don't have a legal background, but looking at this from a business and commercial perspective, to me it seems our position can only be strengthened by being in the room. I never want to have people sitting in a different room making decisions that affect something I'm going to have to eventually pay for. So I certainly think from a commercial perspective it seems certainly the best way to go. Short-term spend, long-term game.
Thank you. Thank you. Oh, sorry, we have another question. Deputy.
Yep, thank you for coming along today and your very articulate research that you've presented to us. Just a question around some of the cases that you've mentioned that have gone to conciliation in the past. 2 things. So you said there were 3 IPC appeals that where council were present, and then you mentioned that around 77% of appeals resolve in conciliation. Are you aware, with sort of either of those 2 facts, if those were state significant developments or if they were cases where council was the local consent authority?
I only reviewed cases where it was an SSD development, so all 19 I found were SSD. Of those 3, the only one that I think where council was a consent authority was the Tamworth Council, which was the wind farm. That was the only one where they had any role as a consent authority.
Very much.
Thank you. That concludes community forum.
Sorry,
Theo. Sorry.
Point of order. Just in regards to the speakers list, one of the speakers raised our awareness to the fact that someone actually applied before them, but
So
was
this is
not-
Theo?
Yes, and that therefore, in order to avoid reputational harm, that
Sorry, Councillor, we have
Council
a very thorough governance procedure on this, as I've just described before. So we can hang around. That's end of meeting. I've called it, but